Hello, my name's Olorotimi Osha. Today is April 14, 2026, and I want to discuss, competency to stand trial, um, evaluation, and the difference between that and a general psychiatric evaluation. I thought this was important for me to make the distinction um, because I saw something on the news today. A woman in North Texas by the name of Cindy Rodriguez Singh, she's being charged with the murder of her 6-year-old son. uh, However, the judge found her incompetent to stand trial, right? So there was uh, an evaluation, and she was found incompetent to stand trial. Now, doing an evaluation, a competency to stand trial evaluation, that's consistent with the Sixth Amendment, right? The Sixth Amendment says that an accused, it has, the rights of the accused, and one of them is that the accused, that they know their charges, that they're aware of their charges, they know their charges, and they're entitled to a fair trial, right? And the other rights, within the legal process, right, in that Sixth Amendment, including their right to legal counsel, right? If they can't afford one, then the court will provide them one. The state will provide them one at the state expense. Their right to a trial by jury, a public trial, these are their rights. So the court wants to make sure that a defendant, right, understands these things so they can have a fair trial. So that's one of the reasons why a judge has the power to order a competency evaluation. By the way, I need to put a disclaimer out there, first of all, that um, although I have a law degree from George Washington University Law School, I have a Juris Doctor, that's Latin for Doctor of Law degree from George Washington University Law School. This does not constitute legal advice, and I'm not your lawyer. I'm not licensed to practice law in the state of Maryland, or in Texas or any other state. I'm not licensed to practice law. I'm not your lawyer, and this does not constitute legal advice. So, the journalists who were reporting on the status of the legal process, right, regarding the woman Cindy Rodriguez Singh in North Texas, who was accused of murdering her son. Remember, people are still innocent until proven guilty, right? The judge ordered a competency evaluation, and she was deemed incompetent to stand trial. Now, however, the reporters mislabeled, they mistitled the evaluation that the woman had. So they called it a psychiatric evaluation. So they mixed it, and then they said, she's incompetent. And people do that a lot. So being found incompetent to stand trial is a specific term for the legal process, right? It's talking about your capacity, your mental state at the time of the trial to understand court proceedings, right? It's with regard to a forensic proceeding. Forensic means legal proceeding, right? It's connected. That's with regard to professionals, right? Professional expertise with respect to legal proceedings, right? That's what, when they're saying forensic, people think forensic necessarily means science. It's not necessarily scientific, but the idea is it's objective and it has the backing of science, right? Um, um, so even law is very subjective. So in America, we call it Juris Doctor because the idea is, we think, we use a scientific process, even though, lawyers really are not scientists, right? So, anyway, I digress. So they called it a psychiatric evaluation. So what she had was not a full psychiatric evaluation, it was a competency evaluation, and it's different from a full general psychiatric evaluation, right? Um, a competency to stand, and again, people normally conflate competency to stand trial, right? Or being found incompetent to stand trial. Very specific with being incompetent. They're two different things. Again, I might do another video explaining that. But being found incompetent under the law. Maybe for instance, an estate can find somebody incompetent and they appoint a guardian for that person because they're incompetent because maybe they're insane, right? They've had there's a psychiatric evaluation and they've lost their marbles. They're insane. That's not the same thing as being found incompetent to stand trial. Incompetent to stand trial is saying, well, they do not understand um, you know, they do not understand the charges against them. They do not understand the current legal proceedings, right? They don't understand the current legal proceedings, and they cannot work with their lawyer, right, to provide a meaningful defense, right? Contribute to their defense. That's just all it means, competency to stand trial. Now, the thing is where it gets conflated, right? Where it gets where the mix up is because of who does it, right? Who performs the competency to stand trial evaluation? It's normally psychiatrists, right? So the judge orders it. So a competency to stand trial evaluation is court ordered. So it's a judge who orders it, right? The it doesn't have to be instigated by a motion by prosecution. No, a judge orders it. Sometimes the defense can order it, especially if it's a if you're using a public defender. In Maryland, the public defender office of the public defender is very notorious for doing that because the public defender's office in Maryland, for the most part, seems to be an appendage of the state attorney's office. The state attorney, they're the ones bringing charges against you, trying to prove that the defendant is guilty. But the public office of public defender, because they're paid by the state, right, and you're supposed to be their client, and they're supposed to have, their a loyalty to you. They often tend to sabotage or sell the defendant out to the state attorney's office because many of them want to become prosecutors as well, and they're not paid a lot of money, they're overburdened, and so they start this process of getting the defendant incompetent to stand trial to help facilitate a plea bargain, which the prosecutor normally wants because they want to avoid a full-blown trial, right? And so it makes it easy for them. So that's an abusive process. It violates the civil rights, the constitutional rights of the defendant. But anyway, let me get back to explaining the difference. So a competency to stand trial, it's ordered by the judge that to make sure that the defendant understands their charges, they know the courtroom proceedings, and they are able to uh, work with their lawyer to contribute to their defense. It's not a general psychiatric evaluation, right? It's not. Sometimes the defendants can be found incompetent to stand trial. So so there are a few questions that the psychiatrist asks. So normally it's a psychiatrist who does the evaluation. There's a psychiatrist or forensic psychologist, right? They too can diagnose, right? Or psychiatrists typically, though. So they ask a set number of questions, right? It's not a lot. So if they fail it, right, the psychiatrist will make a recommendation to the judge that this person's not competent to stand trial, and it's just when the judge agrees with them, the judge concludes that okay, they're not competent to stand trial, then it suspends the case. So the judge orders them to go and get treatment, right, to bring them up to make them competent. Treatment does not necessarily mean they're getting treatment for a mental health because they don't do a mental health assessment when they're doing the competency evaluation, the initial, right? Treatment can just be that, okay, that they give them classes, right? They go and take classes to understand the legal process, right? So they'll just teach them. They can go to classes. It doesn't have to do anything, be that. Now, and then, of course, they want to find out why they're incompetent because the psychiatrist is a specialist. They're trained. So the psychiatrist can know why is it that they're not competent to stand trial. Maybe because they have an underlying mental illness, or they're mentally retarded. So in the state of Maryland, it could be because the person has some form of mental retardation, right? Feeble-mindedness, right? In Maryland, they call it mental retardation. So they're slow, so they don't understand anything. So one of the things that they're going to do is to try and train them or or if they have a severe mental illness, like they're psychotic, right? Then the state makes sure that, okay, they treat them for that mental illness. And that they'll use that opportunity to look at their medical records and diagnose them with some kind of mental illness. And so they can treat them. You'll say, well, maybe this mental illness is what is making them not understand their charges, the legal process, and things like that. So, importantly, though, the competency to stand trial evaluation does not look at their past, right? It's not looking at their past mental state. It's looking at their current mental state and the ability to understand the legal process, right? The current mental state and the ability to participate in the legal process, right? So that's what a competency to stand trial evaluation is. Unfortunately, it's often abused by judges and the state, right? Because it's a way that the state attorney can maneuver, right, the defendant, right, to get them to accept a plea bargain, right? So that's one of the bad things. They can accept a plea bargain that, okay, well, they'll say, well, there are different types of plea bargains. I'm not going to get into that now. Um, Now, it's interesting. There was a case in Maryland, and it's ongoing now. A case of a woman named Catherine Hoggle. Catherine Hoggle, in September 7th, 2014, two of her kids went missing, right? It's been a long time, over 10 years, 12 years. So in Maryland, right? And a judge found her incompetent to stand trial, right? So she was found incompetent to stand trial. And because she was found incompetent to stand trial, the judge now committed her to a maximum security psychiatric facility to undergo treatment. So she was there for a very long time. Kept finding her incompetent to stand trial. Now, under the law, all right, you're innocent until proven guilty. The state can't just place charges on you, right? They can't charge you with a crime without having an opportunity to defend yourself, without prosecuting, right? Eventually, the charge will automatically drop off. So, guess the judge who was finding her incompetent to stand trial, Judge James Bonifant, the same judge who wrongfully found me incompetent to stand trial and committed fraud upon the court and committed me to, he defamed me, found fraud upon the court in a malicious prosecution that I'm undergoing. I've done videos explaining this, so I'm not going to get into that. But the same judge, though. So you see the way he abuses competency to stand trial orders. So this woman, her kids have gone missing. Nobody's seen them. They're obviously dead. And she was charged by the state of Maryland, by Montgomery County, the same uh, state attorney's office, John McCarthy state office, that filed false charges against me in my own home, right? So they filed these charges against her. It's been a long time. Now, Judge Bonifant, sometime it was in 2022 or so, he dropped the charges, right? He dismissed the charges because, of time, a lapse of time, and ordered her to remain for treatment, right? Now, last year, though, she was discharged from the psychiatric hospital, right? Uh, the thing is, the woman, Catherine Hargle, apparently she has a record, a history of being a schizophrenic, right? She suffers from schizophrenia, right? So she had a history, and that was a reason why she was forced to undergo, she had to go and have this treatment, and it was probably contributing to her lack of capacity to be competent to stand trial. But she would be confined to a psychiatric hospital for a long time, over a decade. But she was now released last year, and the charges against her were dropped. But when she was released, the state attorney decided to file charges against her again, because it was like an egregious injustice that these kids have been murdered, they've gone, and nobody's been brought to account. And their father, the family, they they've been so grieved by it, and to see the accuser, right, the mom who is charged with having murdered them and hasn't provided the body, she was just walking free. So uh, they filed new fresh charges against her last year, and they arrested her, and they've detained her. So um, So just to show the abuses of this competency to stand trial order, judges, again, they abuse it. Judges like Judge James Bonifant abuse it, and the state attorney, with the encouragement of the state attorney. So, but let me bring us back to competency to stand trial evaluation. So, the idea of the competency to stand trial evaluation, it's not saying somebody is insane or mentally incompetent or even has a mental illness. Although, for instance, depends on the state. Some states like Florida, there is no requirement for a judge to order. There are no conditions, right? There are no conditions that have to be satisfied for a judge to order a competency to stand trial evaluation, right? If the judge just thinks the defendant might have a mental illness, he can just order it, right? That's all that's needed in the state of Florida. However, in the state of Maryland, it's different. The state of Maryland requires that the defendant has two conditions. One of two conditions must be fulfilled, satisfied, must exist first of all. The defendant has a mental illness, or the defendant has mental retardation. The thing is, Maryland, Judge Bonifant has a practice of abusing it, right? He will just find somebody, he would just say, well, this person has a mental illness, even though he's not a psychiatrist, right? So he acts in a delusional manner. Maybe it's part of his megalomania, and he commits them to a psychiatric hospital because in the state of Maryland, you have a right not to be confined in a psychiatric hospital if you're not mentally ill. You have a right to say no, to refuse. But Judge Bonifant, on pretext that there are charges against you, so the state of Maryland, the state attorney's office files false charges. That was what they did in my case, right? So it's all related to a fraudulent emergency evaluation petition that had been filed by GDA Wari, a judge that was his friend, for instance. Had, in this instance, in my case, apparently, according to what I was told, right, by the police, had approved a perjured and fabricated emergency evaluation petition in which I was never given notice. Everything in it was a fabrication. I was never given notice. I was never given an opportunity to dispute it. My family wasn't given an opportunity to dispute it because GDA lied that he was my uncle. He's not my uncle, right? There's no consanguinity between us. He fabricated all of that. My mother's alive. My siblings are alive, six of them. My family is well educated. My brother's a prominent professor, world-renowned professor. I have a younger sister who's a lawyer. I have an aunt, my mom's first cousin here in Maryland, who's a psychiatrist. She's licensed, authorized to treat, diagnose mental illness. Nobody knew. So the state of Maryland just kidnapped me. And they're having cases like that, because many of our government officials, especially state officials, they are rogues, right? They abuse their authority, like Judge James Bonifant. They commit malfeasance in office. So I'm doing these videos, hopefully that they can be held accountable. To serve as a government official, a public official, you have to be above board. But that's not the state in Montgomery County, Maryland. That's not the case in Maryland. My rights were violated. My constitutional rights were violated. But I have done videos talking extensively regarding that. So I want to take us back to the matter of competency to stand trial. So the competency to stand trial, again, it's a forensic proceeding. I mean, it's specific with respect to a court-ordered proceeding with respect to the pending charges, a case that's going on in court. That's why a competency evaluation is ordered, to make sure that the defendant understands their charges, understands court proceedings, and they can work with their lawyer to provide to help in their defense. They can contribute to their defense. So that's what a competency to stand trial evaluation is for. Now, however, a full general psychiatric evaluation, that's a confidential matter. That's within the purview of your privacy rights. In the state of Maryland, for instance, one has the right to see any psychiatrist they want to see, or if they don't want to see a psychiatrist, right? That's your privacy rights. It's your confidential rights, and they're federal government laws on HIPAA that govern that, right, regarding information. But if for some reason while you've been charged, for instance, this woman who has been found incompetent to stand trial because her son, I'm talking about Cindy Rodriguez Singh in Texas, who was just found incompetent to stand trial. It's not a psychiatric evaluation she's had, just a competency evaluation. Now, if and her attorney had taken a plea, because when you appear in court at pre-trial conference or whatever, when you're asked by the judge to plead, whether you're guilty or not guilty. Sometimes some people, the lawyer, if they want to use a defense of not guilty by reason of insanity, right? They say that, well, they were insane, so they're not guilty because of that. Then the judge can order a full psychiatric evaluation of the defendant, of the accused person. They can order a general psychiatric evaluation, typically with the after a motion by the prosecutor is filed, because the prosecutor would want to know their mental state. So a full psychiatric evaluation looks at the past mental state, right? Looks at the mental state of that person, the history, the historical mental state, the mental, uh, the mental health, the previous diagnosis, and they look at all of that. A competency to stand trial evaluation doesn't. It just looks at the current state of mind, the current mental state, to see if they are able to contribute to their defense, right? They have the ability to current ability to understand their charges and things like that. So the full general psychiatric evaluation, if the defendant pleads, well, they're not guilty by reason of their, of insanity, it makes their confidential, their what is typically their private mental health records. It makes it or it's up for grabs. It's open for discussion, right? It's open for examination, for scrutiny, and so the judge will order an independent evaluator, right? An independent psychiatrist to evaluate uh, the uh, the defendant, and so a full psychiatric evaluation deals with, assessing the mental health, the past historical the mental history of the person, and it can recommend treatment. Now, if the person is found guilty, right? So if they're not guilty by reason of insanity, right? If it's successful, right? If it's successful, because under our law, you can't be convicted of a crime in U.S. common law. You can't be convicted of a crime if you didn't have mens rea, right? Again, I've talked about this. You need two elements that have to be present in a criminal trial in America to be convicted, to be found guilty of a crime. One, the actus reus, that's the actual action, the physical act, for instance, the murdered person, the murder, the killing of someone. The other thing is the guilty mind, right? So the actus reus is the physical action, right? The killing, right? The other is mens rea, that's a mental state, the guilty, culpable mental mind, right? They had to, first of all, conceive of a criminal act in their mind. They have to plan it, right? Conceive of it, plan it. They had the intent. In layman's terms, that's what we call intent. If somebody is severely mentally ill, the our U.S. laws, we think that then that person cannot form mens rea. Then in that case, they won't be able to find them guilty. So if they committed the murder, right, and the attorney knows, then they'll ask that, well, not guilty for. You can ask for a plea that not guilty by reason of insanity. If it's successful, then the judge can order that, well, instead of going to prison, should be sent to a psychiatric hospital and receive treatment, right? And it depends on the psychiatrist to determine when they're well. So that's a difference between a general psychiatric evaluation and a competency to stand trial order. So a general or full psychiatric evaluation looks at making an assessment, right, of mental health in order to recommend and provide treatment, right? They're trying to provide treatment, whereas the competency evaluation, and they're looking at the past mental state, right? The history of that person's mental health. But a competency to stand trial evaluation is looking at just their current state, right? The ability to understand. It's a forensic court ordered proceeding, and the ability of the defendants to understand the current charges and assist, the lawyer to provide a strong defense, right? The best defense that they can have. And so they don't they won't necessarily give them any form of treatment. It can just be classes to understand court proceedings, right? How they should, they can teach them, the legal proceedings, right? So it's testing legal capacity. That's really what a competency to stand trial evaluation is. They're testing that person's current legal capacity, right? Their mental state, how their mental state understands the current legal capacity. And so they can give them training to sort of ramp them up, get them up to speed, right? If they're found incompetent to stand trial. Now, sometimes it can be because it's a psychiatrist who does it, and it's done in a hospital setting sometimes, right? Then the psychiatrist can figure out that if they have a mental illness, right, that's contributing to them being found incompetent, right? And if that's the case, then they'll tell the judge, and then the judge can order a treatment, right? Uh, so that's the difference, right? That's the difference between competency to stand trial evaluation and a full psychiatric evaluation. My name is Oluro Timosha, and I will keep you posted. Thank you.